Okay, I'm gonna start. Let me just start with my background and well, what the topic is. Topic is artificial intelligence, and it's what's going on in the entertainment industry. And there's a lot going on. This in 2025 alone, the first half of this year, there's been a lot of legal developments that we'll be talking about today, and some pending ones, including most importantly, what's pending in Congress. And my background is I've been practicing for 40 years in the entertainment industry. I was an adjunct professor at the UCLA Law School and the UCLA Business School and at USC Law School. I'm the author of a book called The Biz and a book called Taxation of the Entertainment Industry, a treatise. My greatest claim to fame, which I'm the most proud of, is being called Lifetime Legal Legend by The Hollywood Reporter. And I have a monthly online column in Forbes, and I have an entire course on YouTube that you can find by just searching Sky Moore Attorney altogether, just Sky Moore Attorney. And I have basically what I taught at UCLA Law School and Business School. And I am supposed to tell you about MCLE, and hold on, I'm supposed to read something. There'll be a link to the MCLE certificate evaluation form and handout at the end of the webinar. The materials will be distributed via email within 24 hours. So we do provide MCLE credit, and you should get it either automatically, or if you have a problem with it, just write back to me or to Greenberg, and we'll make sure that you get it. I want to take questions today, and so please, if you'll send questions there's a Q&A section, and all I would ask is that you there we go. All I ask is that you make the questions short so that I can actually read them. And I plan to stay as long as it takes to answer any questions people have. So I'm going to do that at the end. And I think we'll fill up the time with what I have to say, and I will stay to answer any questions people have. So now, with that introduction, let's get into the weeds. And the first thing I want to say, and I've said it many times, and I will say it till I'm blue in the face, is that AI is ultimately going to be able to create perfect, creative films, music, books, scripts. We just need to all get over it. And so we need to deal with, you've got to harness it, don't fight it. And it's expanding, and it's getting better at logarithmic pace. There's already shorts on that are almost indistinguishable from real films. And they can create, obviously, the actors, this music, the dialogue, the script, and they're winning awards, and people can't even tell the difference. So they've already won music awards. AI created music. AI photographs have won photograph awards, to the chagrin of the people that gave the awards, because they didn't realize it. And there's been and music kind of leads the way. So the famous one that came out was "Heart on My Sleeve," that was supposedly done by Weeknd and Drake, that was AI created. And we'll be talking about the legal implications of that. And it's all, when you get done with it, it's just neuron connections, and computers can have more than we do. And so ultimately they will outdo us. And so that is what causes all this legal conundrum, copyright, trademark, right, publicity, et cetera, because the ability to replicate humans, replicate existing works, modify them a little bit, and that is what's really the genesis of the chaos that's happening. Now, the big thing that's happening, one of the big things that's happening is fights over copyright. And you can boil it down into basically three categories: upload, download, and then protection of AI content itself. Anybody that owns any existing copyrighted works are suing all AI companies for uploading that content and feeding it to the beast. And the claims are that the uploading itself is copyright infringement because there's some copying going on when you, one way or another, it's being copied up into the computer. And the issue that brings to the fore is whether it's fair use. And the big one, the big argument, right? Well, the biggest case that has just been brought is by Disney and Universal against Midjourney. That just came out a week ago, and or two weeks ago, and it's a phenomenal case to read, and it'll be phenomenal to follow because it triggers upload, download, it triggers all the issues that we're going to be discussing. The arguments for permitting the uploading that the AI companies are making they're all arguing it's fair use, and they're all pointing to a Second Circuit case called Google versus National Association of Libraries, where Google was allowed to upload full text of all these books and then was allowed to show snippets of it when you search for certain topics or the certain book, you'll get a snippet of it, but not the entire book online. And the court held that isn't this a wonderful thing? It benefits society. And basically it was a rule with your heart decision that it was, fair. And fair use ultimately comes down, it's a rule with your heart decision. Every time you hear fair use, you can go on and on about various factors and what the courts say, but ultimately you're deciding is with your heart, do you think it's fair or not? And so the Google case, one court thought it's fair. I believe that analysis has changed somewhat due to a subsequent Supreme Court decision that dealt with Andy Warhol colorizing a photograph of Prince. And in that decision, when you cut through it, the heart of it was, did the owner of the photograph have a reasonable expectation of payment based on what Andy Warhol did using their photograph? And the answer was yes, they did. And therefore, it was not fair use. And therefore, it was infringement. And the photograph owner was entitled to get paid. I believe that has fundamentally changed the analysis on fair use. And that the question is now fairness from the perspective of the owner of the copyrighted material. Did they expect to get paid for the use that is now being made of their work? And the answer, when you look at uploading, is hell yeah. Hell yeah, they expect to get paid. And the proof is in the pudding. They're all suing thinking they should get paid. And so we kind of know what their reasonable expectation is by God, you're uploading my content onto your little beastie AI computer. I want to get paid. And under Andy Warhol decision, I think that is a compelling argument. And the first case that has addressed it has agreed with that effectively, which is Thomas Reuters versus Ross Intelligence. It came out earlier this year, and it dealt with uploading, albeit in a situation that was rather compelling for infringement because it was by a direct competitor of. They were basically taking Westlaw head notes and using it to create a competing service, and the court held that was not fair use. But it did cite the Andy Warhol decision, and it did fundamentally use this analysis, I think, of did the owner of the copyright expect to get paid. The Copyright Office issued a report a couple of weeks ago that was a quote pre-publication report, whatever that is, and they came to they said uploading can be infringement, depends on the facts, but it wasn't per se fair use. And the day later, the head of the Copyright Office got fired, and it's not clear whether they got fired over that report. But it does call into question whether that report is still of any authority, although it may not be of authority anyway because it was a pre-publication report. One of the interesting aspects on uploading, and it came up in a UK case, and there's a big case going on in the UK on I think it was Getty Pictures versus Stable Diffusion. And the question is, where did the uploading occur? And in that case, apparently, most of it did not occur in the UK, and therefore there was no UK jurisdiction. And you could make the same argument in the US. What is interesting to me is that the AI companies do not appear to be uploading outside the US, and they would be well advised to do that if they were trying to avoid this issue. They could go off in the middle of the Atlantic, or they could go to some country that doesn't have copyright protection, and they could upload there because its jurisdiction is based on where the copying occurs. And if the copying occurs outside the US, you don't have US jurisdiction. And so I think, anyway, that has come up in the UK case. It has not come up in the US cases because the AI companies have not alleged that as of yet. And I'm surprised that they were dumb enough to do it in the US. Now the flip side of the coin is the output. And AI, spits out output all the time using the uploaded material. And there's claims going on over this, again, day in and day out. One of the claims is, hey, we're in there somewhere. I don't care what it looks like. Even if it doesn't look like my thing, by definition, you uploaded mine, and now you're spitting stuff out, and therefore it's copyright infringement. Those claims are losing because at heart, all art, whether it's human created or otherwise, is based on pre-existing art. And therefore, if I'm writing a book, I'm influenced by all the books that I've read, and therefore, to some extent, those books are in whatever I've written. And so those claims are losing. The ones that are winning is if the output is similar enough to the existing work, to the underlying work, and the analysis goes as follows. Step one, is it close enough that it is a derivative work? And that is a rule with your heart question. You look at the original, you look at this whatever the AI spit out, and do they look similar enough that you would rule with your heart that the new thing is based upon or substantially similar to, and that's the wording the courts use, to the original, in which case it's a derivative work, and that's kind of your first step. On the Disney versus Midjourney, that step was kind of easy because the output was identical to the input. That is, when you read the complaint, they've got side by side pictures, and it's completely identical. So that A established the uploading was clearly copied, and then the downloading was as clearly copies. Once you decide that it's a derivative work, the next step is it fair use? What you're doing, what you're doing with it, and well, actually, there's a step before that, which I will get to, what I think is going to come up in Midjourney. Step two by the AI companies is, we didn't do it. Our customers did it, and we just work here. It's the we just work here defense. And Midjourney, I guarantee, was going to raise that, and they're going to say, hey, we didn't do the infringement, the output on the output side. Our customers did the output, and then one of the problems for Midjourney is that they put it up on their web system, but I'll hold that to the end and talk about that. So the we didn't do it theory is going to get litigated, and the issue there is going to be aiding and abetting, secondary liability. It's the Napster and Grokster approach of finding liability for the companies that encouraged it. The other step is fair use, and you'll argue, and the AI companies have, that whatever's output is fair use. Now, it used to be that if you modified the original work, that there was a thing called transformative defense, that if it was modified and transformed, that would be a fair use defense. The Andy Warhol decision effectively threw that out because Andy Warhol had clearly colorized and modified and transformed the photograph, and the court said, bananas. Again, it was, did the owner of the original work expect to get paid? The answer was yes, therefore it's not fair use, even if you have modified it, revised it. And AI is very good at modifying and revising. And so that very potent defense got thrown out effectively by the Andy Warhol decision. And so the bottom line is, in most cases, the use on the output side is not going to be protected by fair use because Merely modifying it won't work. And it will depend what you're doing with it. But if it once you cross the line of saying it's a derivative work, and you're just somebody else is making it and doing it, like that's kind of like what's going on now. One of the arguments might be, well, the consumers are just doing it for personal at-home use, and therefore it's fair use. And that brings back the old Betamax decision regarding Sony making the Betamax that could copy videos. And this also goes to the liability of the AI companies in permitting it. And that this is going to be a big argument. The AI companies are going to say, we're just like Betamax. We're letting people copy it, and they're copying for at-home personal use is fair use. And we just made this system available. So on the one hand, you're going to have AI companies arguing Betamax. And on the other, you're going to have the Disney and Universals of the world on Midjourney. They're going to be arguing secondary liability. You encouraged it, you allowed it, you effectively made the tools available and told the people to do it. Now, I will tell you, so it's Grokster and Napster on one case, and it is Betamax on the other. And I will tell you that Midjourney falls deeply and heavily into the Napster Grokster case. And I think that what they did went way beyond the pale. They put up on their website pictures that consumers were doing of Star Wars and everything else. So the consumers were downloading and then putting it up. Now, what Midjourney is going to say is, hey, we're protected by Communication Decency Act Section 230, which says that we're not liable for stuff that's posted on our system by third parties. And it's, we just work, it's the we just work here defense. But in the Midjourney case, it really is so clear. It went so far. They were showing people how to do it, what to do, and here's examples of our customers doing it. So I think it's pretty clear that that's going to be secondary infringement liability, and I don't think it will qualify for fair use. And so I think that I think they're in trouble on that. The copyright report that I mentioned earlier also addressed the output side and also said that might not qualify for fair use. And once again, that person got fired the next day. And so the question is that report, is it enforced? Is it authority at all? Because it's just a pre-publication report. And second, is the firing indicative of that somebody is not happy with that report? Unclear. Next aspect of AI, which is the third aspect that I mentioned, is that you cannot protect AI created material with copyright. The Copyright Office has said it. The courts have said it. All the courts have said it. And there's some people still fighting it, but they're going to lose. So the bottom line is AI created content is not itself protected by copyright, and which has all kind of implications. For example, you can't do a takedown notice. Other people can copy it. State law won't protect you because the copyright preempts state laws. And so if it's permitted by copyright, then it's not protected by state law. And so what do you do? Now, what people are doing is they're arguing, well, I was so creative in the prompts that I used that therefore the output is really what I did. That one is so far losing. The other thing is, this is really like Photoshop, and I modified the output, and therefore it is my creative work, and that is kind of winning. So if you modify the output and you can show that the elements that were created by a human, but then it gets a little bit difficult to parse out what was created by human, what was created by AI. But in theory, if you put enough creativity into the end result, you can get the end result protected. What I think is going to happen as a practical matter is what I call the I forgot defense. And the I forgot defense is people will create stuff with AI and they will register it in the Copyright Office under their name as the author, and they will forget that it was actually created by AI. And in most cases, no one's going to know. I mean, how are people going to tell? Because AI is so good these days that you really can't tell whether it was created by AI or not, particularly if it's written. I mean, how do you tell a writing and even again, even photos, music, everything else, it is difficult to tell. So what'll happen if people get alert to the issue like down the road is there will be litigation over the question, and there will be discovery, and they will get into prove, and then the question will be who has the burden of proof. Prove that you did this by as a human versus an AI, and and give us your record, your computer records to show what you did, and there'll be a lot of litigation fun on this question of proving what elements were added by AI, what was created by a human. Here are some suggestions that I have for as a practical matter for protecting protecting copyright. And the first is to have a human person write the treatment for if you're going to do a film, for example, have a human write the outline of the treatment, and have that registered in the Copyright Office. And then everything else that goes from that will be a derivative work. So if you then have AI create the screenplay and the film and the actors and everything, the ultimate film will be protected as a derivative work based on the treatment that was written by a human. And although people could copy the AI created elements in that film, they won't be able to copy the entire film because it will be a derivative work based on that original outline. So that's my first plan. Second plan is that you could have AI create everything. Just say, go for it. Do the script, treatment, script, film, everything, and have somebody at the end do something to the film to add creative elements, whether it's colorization or little special effects or adding or modification like you would with Photoshop. And intersperse it enough in the film so that nobody knows where exactly it is, and they wouldn't be able to, they're at risk if they try to copy the film that they won't know what elements were created by a human. It's enough in there. And then you can protect the entire film that way using the based on I did the creative side. It was created by a human. Now, what's looking back, I want to now summarize on all of this in the Disney and Universal versus Midjourney. So here's the lawsuit and the defenses. Lawsuit is the uploading was copyright infringement and it's not protected by fair use. Midjourney's defenses are going to be either A, I did it outside the country if they're clever, or B, even if I did it in the US, it's fair use and it's the Google case. So this is gonna go headlong into the Google case versus Andy Warhol case. Then the other side is downloading. And again, this was downloading appeared to be done by Midjourney's customers, and Midjourney is going to say, I didn't do it. They did it. So go sue them. And oh, by the way, though, we put it up on our website and showed everybody what you can do. Isn't this great? But they're going to say that's protected by Circular 230. And you can send in Disney, please send in a takedown notice, and we'll take it down if you want, but we don't have any liability for it. And I just and the personal use by the consumers will be protected by fair use because it was personal at home, not sold. It'll be the kind of the Betamax making one copy of the video for backup, supposedly. So that's going to be a fascinating case. And as I said, I think this is going to be the Napster side of the equation. Midjourney was clearly with knowledge, assisting, aiding, and abetting, and encouraging infringement. They were doing everything possible to make money off of it, and they made a lot of money off. Now, next up at bat is trademark, and the first thing I want to give is just a quick summary of the major of trademark law, and the main branch of trademark law, which is trademark is aimed at no consumer confusion as to the source of the goods. It's very different than copyright. It is and this is trademark owners get all excited about this and wish that they had copyright protection, but they don't. It's only if the trademark is used to cause consumer confusion as to the source of the goods, so that it is okay in a film that is created by AI or otherwise to have trademarks appearing in the film. If AI happens to create a McDonald's, you know, whatever, in a Mercedes driving across the screen or whatever it does, as long as it is not in creating consumer confusion. Where this came up in AI was that my favorite case so far on this is that Stable Diffusion uploaded all of Getty's images and then spit them out. And when you ask for various things, now, of course, the images that you spit out were very different, but there it was in it said on the photos that came out, Getty images. And so that was a tragic error for Stable Diffusion because that clearly causes consumer confusion as to the source of the goods. Because there you go, you've got the watermark, but yet you can read it and it says Getty images, and that is it's like having a film created by AI that says presented by Disney, and we're going to call it Galaxy Wars, and you can imagine that if AI does that, which it will want to do, by the way, because it's uploaded, it realizes how popular that is. Yeah, Star Wars is, and that will be obviously subject to trademark infringement and um, and will cause liability. The flip side of it is if you have stuff that's created by AI, how do you protect that? How do you protect, if you can't protect it by copyright, can you protect it by trademark? And the one that is becoming the most apparent on this is that there are already influencers on social media that are entirely created by AI, and they have millions of followers. And so it's already happening. And I tell you where it's going to go, where it's going to happen, no question. There will be AI created actors in films. And what will happen is that those actors will become characters in their own right and will appear in the next film and the next, it'll either be in a franchise or even otherwise. And if you can't protect those with copyright, which you can't, can you protect them with trademark? And this must have this must have already occurred in connection with the influencers because they are being monetized, they are making money for their creators, and somehow or other those creators must have a way to protect them, and it's got to be trademark. And so what I've been thinking is how do you protect it with trademark? You've got to again create it as a source of a good. You've got to create it so that it becomes its own brand. The influencers I get, you could have, it's call it, Mrs. X, and Mrs. X is the brand. And as long as maybe it's a cooking show or whatever, created. So it's an AI character that does cooking, and you know that, aha, I want to go and see the cooking show under Mrs. X, and the trademark is Mrs. X, and her image is becomes a trademark. So you could make the image distinctive, make it so it doesn't look like an existing person, use it extensively in social media, use it as the when you have the title of the whatever, have that image, try to identify it with it. Give the name a distinctive name, hopefully better than Mrs. X. The more distinctive the name, the better. And file a trademark registration for it. So what I would envision for AI created actors is that a studio wants to create a popular actor, and they could give that person a backstory. They could have an supposedly off-camera life, which is what social media do, by the way. The social media AI influencers they live the life of the rich and famous. They have Ferraris and mansions, and they go to fancy parties. You could do that for an actor as well, and then have that, and people will actually kind of follow it and accept it, even if they know it's AI, and then have that a person appear in multiple films, in a franchise of films, and you could protect that image with trademark. And so that's what I think is going to happen. And I think it's probably already happened with influencers. The next big thing that's really come up in a big way for artificial intelligence is the right of publicity. And um, let me just give you a background of right of publicity, the summary of where things stand right now, and why and where this comes, why this is so important with AI. So right now, the the fundamental rule, as a prima facie case, is that anybody, whether they're celebrity or not, can sue anyone else who uses their name, likeness, or image for any purpose. That's a prima facie case. There's a lot of defenses that apply, but at heart, that's the right of publicity. You, individual, celebrity or not, has the right to stop somebody else from using your name, likeness, or image. And then now from that broad prima facie case, you get into defenses, and there's a lot of defenses. And this is where all hell breaks loose, because the states are in complete disarray as to what defenses apply and where you can sue. So the first big divergence at the state level is some states permit jurisdiction based on where the image is shown. If the film is shown in Kansas, then you can sue in Kansas. Some states say no, it has to be based on residence of the person, the plaintiff, residence of the plaintiff. So you have this residence versus point of exploitation divergence. And then you have all kind of defenses that are divergent. Some states say, oh, it's protected if it's in an expressive work. Some cases say it's protected if it's transformative, kind of going back to the copyright fair use concept of just transformative in the old version of where you modify the output. So there was an important case of the Winter Brothers, who were singers, and they were transformed into these half-worm creatures, and the California court held that was protected by this transformative defense. And this is critical for AI because AI can transform images. And so one of the questions will be, will the Andy Warhol decision that threw that out for fair use apply? Will courts start applying that in the right of publicity, which I hope so. Some courts say, oh, copyright preemption, if the image appears in a copyrighted work, that therefore that is protected against the right of publicity claim. They call it copyright preemption. I think the defense is ridiculous, but a lot of courts have upheld that. Now we get into the AI fun aspect of it. California enacted legislation at the beginning of that became effective in 2025, January 1, that there was two important issues for digital replicas. Number one, that an estate of a celebrity can sue if somebody uses a digital replica of the celebrity in entertainment, in a film. And there used to be a gaping loophole that permitted that. That loophole was deleted with respect to digital replicas starting on January 1, 2025. Interesting, not other images, but it has to be a digital replica. The other thing that California did as of January 1 is they supposedly prohibited contracts that permit somebody to sign away their right to make digital replicas. So a contract is not enforceable if a person agrees that a studio or whoever can use their image to make a digital replica. It's basically it is void basically on public policy grounds. The problem with that statute is that it is riddled with loopholes and exceptions, and one that is valid and a lot that are not valid. The one that is valid is that if you're a member of SAG-AFTRA, then this prohibition doesn't apply. The contract is in theory enforceable, but then you go to the SAG basic agreement, and they have even more protection under that. So I'm going to talk about that later. So there's a SAG exception, but do not cry for the SAG members because they get more protection under SAG. The other exceptions are if the person is represented by a lawyer and the contract is clear, and that's going to be the biggest loophole. Of course, you just have a lawyer. Next is if the digital replica does not replace work that the person would otherwise do, then it is enforceable. Or if the contract has a reasonably specific description of the work, of what you're going to do with it, then it's enforceable. And so those are three huge gaping loopholes in this statute that make it toothless. The truth is it's completely toothless, other than for SAG, but then go to SAG and don't worry about SAG. New York is it's about to pass legislation. The Senate, it's going to get signed. So I'm going to treat this as passed because it's just about to be signed by the governor. They have just passed legislation that requires any advertisement that uses an AI created person, that the ad must conspicuously disclose that fact, unless the image is of a modification of a real person, in which case that person's going to have a right of publicity claim or has consented, or it's an advertisement for a film that has they call it a synthetic performer, that has that synthetic performer in it. So if a studio does do a film with an AI created character, they are allowed to put that in an advertisement for the film without conspicuously disclosing it. All other advertisements that use synthetic performers have to conspicuously disclose that. And that will be effective as soon as once they pass it, which is pending. What is interesting on all this is federal legislation that is pending. And one thing that got passed, but the one that's pending is there is a federal in this quote big beautiful bill. There is a 10-year moratorium on the enforcement of any state laws that regulate artificial intelligence. And it is just the most broad. It's like one sentence and it's killer. It just says you can't enforce, states can't enforce legislation, even prior legislation, like we just talked about, California and New York. And here's the fun part of it. It says you can't enforce legislation that regulates artificial intelligence. Now let's just look at the New York and California law. The New York law, the way it's worded is that a synthetic performer is one that is created by, quote, artificial intelligence or a software algorithm. And so what New York is obviously going to say is, okay, ignore the artificial intelligence part, but we have our laws also apply to someone that is created by software algorithm, and we're just not going to call that artificial intelligence. And therefore, our law we can enforce our law. That's what's going to happen. That's what New York will say. California is even better because California, the laws that I just said about prohibiting contracts and deceased celebrities, that refers to the digital replica is, quote, and I quote, a computer-generated, highly realistic electronic representation. It does not use the word artificial intelligence like the New York law does. And no doubt California is going to say, we can enforce our laws because we don't use the word artificial intelligence. And so this will, stay tuned for whether whether this moratorium actually gets enacted. It's highly controversial. And if it does get enacted, brace yourself for litigation on whether it what state laws it applies to, because state laws I think will be obviously using different wording and trying to get around it by calling artificial intelligence something else. Federal legislation did get passed a couple of months ago that is called, or 1 month ago in May, the Take It Down Act. And the Take It Down Act basically prohibits the digital replica of somebody, but only if they're nude. So it is aimed at revenge porn, and it's aimed at the Tyler Swift fiasco where somebody took her face and put it on a naked body and circulated it. It's aimed at that. And this would have been the perfect time to deal with the whole right of publicity issue in general, but for some reason they just limited it to basically pornography and naked, and not necessarily pornography, but naked images. What is pending and was going to deal with the right of publicity is what's called the No Fakes Act. And the No Fakes Act is federal legislation that was supposed to create a uniform set of laws across the United States. It wasn't going to preempt state laws, but it is like trademark law, which is a uniform set of laws, and then states can do whatever they want. But at least there would be a uniform set of laws that would set effectively a minimum protection. And that law is just floundering and is going nowhere fast. So I'm not putting any bets that law will pass, unfortunately. And the Take It Down Act was the perfect opportunity to do it, but they didn't. Which brings us to defamation. And there was a case, you wouldn't think AI, what's got that to do with defamation? Well, computers hallucinate, and AI does, and it spits out false facts and some of them are false, nasty facts. And there have been a number of lawsuits suing AI companies for generating false defamatory facts. There is a case that just came down last week, literally. It's called Walters versus OpenAI, and it's very important. And it's important because there are two strands of defamation, two different tests. One is if the person's a public figure or it involves a matter of public interest, and the other is for the rest of us, hoi polloi. And if it involves a public figure or a matter of public interest, there is a defense that the person that said what the bad, nasty things that they said believed it, even if it was false. And it's a subjective test. And the quote, to quote the Supreme Court, there must be sufficient evidence to permit the conclusion that the defendant had a high degree of awareness of probable falsity. And that is a very high standard. So even if it's false, it's nasty, it's defamatory, if the person can prove that they believed it, that is a defense. Outside of public figures, the defense generally is that it was nasty, false, all that, but that a reasonable person would have believed it. So if you just say some goofy thing as a joke and a reasonable person wouldn't believe that, then that's not defamatory. Which brings us to Walters versus OpenAI, critical case on this because it dealt with both. And the plaintiff was a public figure. And what happened was that ChatGPT had spit out false, nasty facts about him. And he sued OpenAI and said, you can't do that. And the court said that a computer fundamentally can't subjectively believe that what it spits out is false, and therefore you can't meet that first prong for public figures. That it is an absolute defense that there was no subjective awareness of falsity by a computer, and therefore it's not defamatory if you're a public figure. The net result is AI can defame celebrities at will, basically. The second aspect of it, which is even more interesting, is they said a reasonable person should know that artificial intelligence computers hallucinate. It's been in the press. They often tell you, there's a disclaimer often that says that, and therefore a reasonable person shouldn't rely on it anyway. So even if you're not a celebrity, you might not be able to, in this case, we're not able to bring a claim because no reasonable person would believe it. What that means for the combination of those two is effectively AI is now free to go defame at will, and that's going to, they're always going to say either it's public figure and the computer didn't believe it, or they're going to say no reasonable person should believe it because we hallucinate. And we told you that. So they're defamatory proof. Another issue that comes up on on for AI is the false advertising, state law claims, false advertising, unfair business practice, fraud, whatever you want to group it as. And the one that came up after Michael Jackson's death is that Sony put out a record that they claimed was created by Michael Jackson. It was in fact created digitally with some aspects of AI. And that went up to the California Supreme Court and was held to be unfair business practice because they were purporting that it was being done by Michael Jackson. If you're a distributor and you're buying a film, what do you do? What do you do in a world where AI content is not protected, and so that anybody could go and steal whatever your film? And so you have two potential protections, and I've had to deal with this already a couple of times. Step one is you need to get reps and warranties from the people that are giving you the film or the script or the option, whatever it is that you're buying. You need to get reps and warranties from somebody that hopefully has a deep enough pocket to protect you. But given that a film can cost, $100 million, good luck finding a deep enough pocket to protect you on that. And so the other protection that you can do is AI detecting software, but this is the arms race, and AI is getting so good that the AI detecting software can't really keep up with it. And so it's right now, sometimes you can tell, but sometimes you can't. And my vote is that AI will win. And AI you won't be able to detect it, which brings you back to your indemnity. And what do you do? And there's no good answer to it. There really isn't. If you have a claim, let's say you have a claim for copyright infringement, trademark, unfair business practice, defamation, who do you sue? Let me give you some alternatives. You sue the programmer that wrote the software for the AI. Do you sue the AI company that allowed this? Or do you sue the owner of the content that the AI spit out? And so that, because all of those could be different. And there is litigation on this precise issue. And right now, there's no clear answer on who you sue. You sue it. Try to sue everybody. But I think that is going to be a fun issue. How are the guilds dealing with it? Well, the guilds are certainly awake to the issue, and the DGA did a good job. The DGA in the last round got a 3-year kick the can down the road. The studios cannot use AI to replace a DGA member, which effectively means that they cannot make a film entirely with AI, because that would obviously replace the role of the director. So they've got I think they've got another year and a half to go before they have to refight the issue. The WGA got a very interesting provision that said that material created by AI is not literary material for purposes of the guild agreement. That was sometimes interpreted that studios couldn't use AI to create material. That is not correct. Studios can use AI, but whoever next touches it becomes the deemed author of it for purposes of credit and compensation. So just to pick an example, if a studio uses AI to create a screenplay and has a writer polish it at the end, that writer will become the author of that screenplay for purposes of credit and compensation. And the real question is, with a drum roll, what happens when the studios just replace writers completely with AI and don't have a writer touch it? And now, on the one hand, you could say, well, then they won't be protected because AI created it. But what if they do the approach of having a human write the original, a non-WGA writer write the original treatment, or they buy it from someone who's non-WGA, and then have the AI create the screenplay and get protection as a derivative work of the original treatment. That battle will come, I guarantee you. And the WGA is obviously going to fight that in the next round. and that's tricky. And the reason it's tricky is because the guild agreements only apply to employees, and they can't stop a studio from using, a crane or a camera or a computer. And so because it's not within their jurisdiction. So it'll be an interesting battle. This similar issue for SAG, which let's talk about that. What did SAG do? Basically, SAG got protection for their actors that on a fundamental level that the studios can't use the SAG members' images to use AI to recreate them in other films without consent, compensation, residuals, the whole 9 yards. There is the big issue, which is coming, is what if the studio doesn't use the image of an existing actor, they create a new one. This is a synthetic performer. And the guild agreement says that if the studio does that, quote, they have to give notice to SAG and an opportunity to bargain in good faith over, quote, appropriate consideration, if any. Now, I guarantee you the studio's opening bid on that is that the appropriate compensation is zero. And the SAG will obviously have a contrary view. And it's not clear where this goes because, as with the Writers Guild, the SAG exists under labor law, which is to protect employees, which is people, and they can't stop a studio from using a crane or a computer and because it's not a person. So this will be an interesting battle. Although the way the DGA went at it is they just said, you can't do something that replaces a person. And so they tied it. They didn't say you can't use AI. They just said you can't use AI to replace a person. So maybe SAG will go at it that way and say you can't use AI to create to replace someone that is a person. And so maybe they can tie it on that way. Next is I just want to talk about, put this in context. Heart on My Sleeve by Drake and Weeknd, that came out a couple years ago. There was no copyright protection for it because it was created by AI. Universal would not have been able to take it down, but for the fact that it had a small, short clip of a copyrighted song that was sampled inside there, and they were able to do a takedown because of that. One question would be, did that song itself infringe prior songs by Weeknd and Drake that were similar to the final song? And it appeared the answer was no. It was different enough, even though it was similar in tone and voice, but it was different enough that it didn't directly infringe the prior songs. How about trademark? And the answer to trademark, remember, trademark is consumer confusion as to the source of the goods. And there was no, it said created by AI. So they effectively defeated a trademark claim because consumers could see that it was created by AI, not in fact by Drake and Weeknd. Similar for if there was a false advertising claim, they defeated that because it said created by AI. So there was no lies. They didn't say this is real. And that avoided a state law claim. And then the last is, what about a right of publicity claim by Drake and Weeknd? And I think they would have a very good claim under right of publicity because there was a reference to their names, their voices were being used. But now you get to the state law problem of the defenses depending on the state that you're in. And some states say that there's protection for expressive works, and this was clearly an expressive work. Some cases say that it's protected if it's transformative, and this was clearly transformative. So maybe there would be protection depending on the state that they're in. So anyway, that really brought a lot of these issues to the fore. And it was, and again, music often leads the way, just as it did with Napster and Grokster and piracy. Next thing I want to just talk about with AI is it is absolutely mind-boggling how many lawyers are using AI created material and are getting caught doing it because the AI is hallucinating. The first case was 2 years ago, and I thought, oh, this will never happen again. It was in the press. No one would be that stupid to do it again. And now then it became monthly, then weekly, and now almost every day I read a case where a lawyer is getting sanctioned because they relied on AI to create something. And so the good news for lawyers out there is so far we're not being replaced by AI. Um, because of its tendency to hallucinate, which is just it's what's shocking is the lawyers that actually rely on it and submit briefs to a court that actually has the citations in it. Last but not least, let me just give you if you some fun stuff. The advertising position part of the program. I want to say, if you want to be added to my newsletter list, all you have to do is send me an email with the word "add" in the subject line. And my email is smore@ggfirm.com. Again, I have an entire free course on YouTube you can search by Sky Moore Attorney altogether. I have a monthly column on Forbes that you can read. And I have, most importantly, my book, The Biz. And let me see if I can pull that up for you. That is, 1 second. Let's see if I can share in my screen, and The Biz. And it's on Amazon, and it's in its 6th edition, and it's so, I think we're up to like 50,000 copies. Most of Hollywood has it. Everything on the business side of the industry is covered in that book. I would strongly suggest getting it. And with that, I will take some questions because we do have we have a couple of minutes, and I would be honored to answer as many questions as you have. And by the way, if you have any questions after this call, after this show, email me, call me. I'm glad to take questions because it keeps me abreast of what's going on in the real world and makes me think about difficult issues. And I love doing it. So if you've got questions after the show, please send them. I would be glad to do it. With that, let me see if I can take questions. And Q&A, there we go. Okay, ready. First question, I said, you say, write the treatment. How many words need to be in the treatment? I would say a good outline, 2 pages. Let's make it 2 pages of that. What if AI writes the treatment based on a prompt? No, I don't think that will work. I don't think a prompt will work. I think you need to have a human write, I'll say at least a 2-page normal treatment. Next, if my IP is protected by 2 trademarks, are my original copyrighted characters protected under the trademarks? No. Copyright is different. Trademark, so, well, it depends. Some images can be protected both as a copyright and as a trademark. So the answer to your question, Sophia, is it depends. Depends on what the images are. Okay, question's too long. Again, please keep the questions short. What about studio AI created and then the writer works on it? Yes, but what if the writer doesn't work on it enough for copyright purposes? Is the writer liable in any way? No, the writer, if they only do a few words, well, first of all, if they only do a few words, it's not going to work. You've got to modify it. If you want copyright protection, it's really got to be modified enough to be independent creative by a human, but the writer will not be liable if all they did is they write a few words. Most important question here, am I AI generated? In time, I will be, no doubt. and my estate will hopefully be able to protect the use of my AI created images. And with that, I would like to thank you all for attending and call it a day. And thank you very much. You get AMCLE credit if you want, and hopefully it'll all be circulated to you automatically. So with that, hasta la vista.